Good day, Crime Talk aficionados. It is Sunday, and we have the weekly recap for the week of October 14th of 2024, all conveniently located in one place. That's right, the top stories throughout the week, right here for you. Thanks for watching. We'll see you next time. And remember, the Constitution matters. Next, we got some real death penalty litigation taking place in Idaho, something we haven't seen on the last two death penalty cases that we saw in the Lori Vallow case. In the Lori Vallow case, as well as the Chad Daybell matter. Obviously, both of those cases became death penalty cases. Lori Vallow got the death penalty enhancement charges taken off of the table or for consideration because the prosecutors failed to turn over discovery. Chad Daybell waived his right to speedy trial and gave his defense attorney time to prepare. But there really wasn't a whole lot of motions practice as it relates to the death penalty. Well, that's not the case in the Kohberger matter. Now, in death penalty litigation, normally you're attacking everything, and we'll talk about them in a second, what's taking place. But that's the heart of the death penalty litigation. A lot of constitutional issues. It's cruel and unusual punishment, societal standards. That's the crux of it. We didn't see that in the previous cases. But the prosecutors have had to respond to the death penalty motions filed on behalf of Bryan Kohberger. And needless to say, the prosecutors are asking the judge to reject the arguments from Kohberger's defense team, asking for the ruling that the death penalty in this quadruple murder, and to shut down the request to exclude an outside expert to testify on the constitutional issues regarding the capital punishment. Kohberger's defense team, led by Ann Taylor and Elizabeth Mathis, made numerous requests outside the boundaries of established precedent. Prosecutors wrote in their response this week. Now, the Kohberger's lawyers also argued that the state has no viable method to conduct execution and that there has not been enough time to adequately prepare the case against him. Now, the thrust of the defendant's argument is that the applicable aggravating factors in a capital case must be presented to a grand jury, what the defense attorneys are arguing. But the attorneys on the prosecution side disagree. They say in their arguments that their arguments squarely foreclosed by binding Idaho Supreme Court precedent. They wrote that they met their own legal obligation by including a probable cause affidavit in the superseding indictment and by notifying the defense that the state planned to seek the death penalty within 60 days of his arraignment when a judge entered a not guilty plea on his behalf. Now, under the law, they added, they were not required to include additional probable cause for each aggravating circumstance that led them to seek the capital punishment. They also rejected Kohberger's argument under the Eighth Amendment that the death penalty could be cruel and unusual punishment if the prosecutors seek it without consulting a neutral fact finder. The prosecutors also asked the judge to reject the defense request for expert testimony against the death penalty option in a separate filing. They argue that it is very well established in Idaho that testimony containing conclusions of law by an expert witness is generally inadmissible pursuant to Idaho case law because the expert witness would then offer a legal conclusion and it invades the province of the court to determine the applicable law. Last month, the defense filed their motions attacking the possibility of the death penalty on numerous grounds, ranging from contemporary standards of decency, evolving standards of decency, where maybe it wouldn't be, community wouldn't want the death penalty. And the defense claimed that Idaho's two legal methods of execution, legal injection and firing squad, violate both the Eighth Amendment, and only 26 people have been executed in Idaho since the state introduced capital punishment back in 1864. The death penalty is now carried out by lethal injection, and the state legislature passed a law in 2023 that allows firing squad if lethal injection drugs are not available. Now, although the prosecutors have previously said they want the death penalty, their latest filing is in response to the defense request that the death penalty be ruled out. Now, there were a total of 13 briefs submitted last Friday, and the prosecution rejected all the claims that the public did not favor the death penalty. And the 14th Amendment, they asserted that the firing squad was never constitutional. Now, the crux of the defendant's arguments is that there has been a major shift in public opinion regarding the morality, decency, and the humanity of the death penalty. The prosecutors, however, pointed out the majority of the United States have the death penalty despite defense claims that it was somehow out of step with modern social norms. So let's unpack this. These are all going to be denied. These motions are all going to be denied. The death penalty in Idaho is not going to go away unless the voters of the legislature take it away. The United States Supreme Court has said that basically this is an issue for the states, but that the death penalty is not cruel and unusual punishment. And even when somebody is in fact executed, the Supreme Court said, hey, you're entitled to, death, but it doesn't have to be completely painless, because there was an example, I believe, in Mississippi where there was concerns that the drugs didn't work, or, the Supreme Court said, no, it doesn't have to be completely painless. All right. And the issue that they're trying to make, and this is what the defense has raised from the beginning, is when Bryan Kohberger was indicted, he was indicted on the burglary count and then the 4 counts of murder, so 5 counts total. What the defense is saying is that there's a United States Supreme Court case that says that if you have certain enhancements and penalties, things that would increase the penalty, that has to be basically pled, proven beyond a reasonable doubt to a jury. It's called the Apprende case, all right? So, for example, if somebody committed a crime and they used a gun, you have to plead that there was a gun. So the defense is saying, hey, all those aggravators, you should have pled those in the indictment. And since that you failed to plead those in the indictment, you shouldn't be entitled to present them to the jury as aggravating factors, and hence no death penalty. I think the court will reject that. Now, will it make for decades and decades worth of litigation at higher courts? Yes, it will. But that's what death penalty litigation is supposed to do. The ultimate goal is to delay. That's just reality, ladies and gentlemen, and usually it works until 20, 30 years later, when just about everybody that's involved with the case has since passed, and they will go forever. We'll see how it works out here. My prediction is denied. What do we know about the sheriff and the judge case down there in Kentucky? You know, the sheriff that shot his friend, the judge. So it's been a month since the Kentucky sheriff was arrested at the scene of the district judge's shooting. And the case against Sean Mickey Steins is now in the hands of a grand jury for a potential indictment. Ladies and gentlemen, there will be an indictment, and it will be an indictment for first-degree murder. Well, the then sheriff, who has since stepped down from his position as sheriff, is accused of fatally shooting District Judge Kevin Mullins in his private chambers at the Lechner County Courthouse back in late September. Now, obviously, the former sheriff has pled not guilty to the charges of murder, and his attorney is hinting to a possible defense strategy this week, which basically says, hey, this was nothing more than reckless manslaughter. Heat of passion is really what it boils down to. So here's a timeline of what we know thus far, all right? Now, prior to the fatal shooting there in Whitesburg, the two men were known to be friends for many years. And according to the Facebook account, Steins is from Neon, Kentucky, and resides in McRoberts, an unincorporated community there in Lechner County. Now, Steins had served as a bailiff in Mullins Court for several years before he was actually elected sheriff in 2018. We know Judge Mullins lives in nearby Jenkins, which is about 15 miles east of Whitesburg on Kentucky's border with Virginia. And beginning back in 2001, Mullins served as an assistant Commonwealth attorney there in Lechner County, and he was appointed to the position of judge in the 47th Judicial District, which provides over the Lechner County. Now, he was appointed by then Governor Steve Beshear, and he was elected to the position that following year. Now, on September 19th, just before 3 p.m., the Kentucky State Police received a report of shots fired inside the courthouse, and the Lechner County Coroner's Office pronounced the judge dead at the scene. Now, no one else was injured, thank goodness, and the Sheriff Stein surrendered himself to police without incident, and he was arrested at approximately 3 p.m. and booked into the Leslie County Detention Center, about an hour drive from the Lechner County Courthouse. Now, the Lechner County courts invoked an emergency order to cease all operations that day until normal operations could be resumed. Now, about a week after the shooting, Steins appeared virtually for an arraignment while he was jailed at the Leslie County Detention Center, like I said, about 50 miles east of Whitesburg, Kentucky there. Anyway, Steins, who's now facing murder charges, pled not guilty on that day. Now, while he appeared at the hearing with representation from the Office of the Public Defender, Mr. Steins would later hire a private attorney by the name of Jeremy Bartley. So the Kentucky attorney for the 27th Judicial Circuit, Jackie Steele, serves as prosecutor after the Lechner County Commonwealth's attorney, Matt Butler, recused himself due to family ties with Judge Mullins. Now, following pressure from Governor Andy Beshear, Steins announced his resignation from his role as sheriff, a position that he had held for about 5 years. Now, just a day ahead of his afternoon court appearance at the Morgan County Judicial Center. Now, about a week prior, Beshear formally requested Steins resign in a letter from the Attorney General. Now, while Beshear's letter asked for a resignation, the Kentucky governor said that if Steins didn't step down, he'd move forward with removal under a statute that allows for such removal if there is some sort of neglect that the sheriff is participating in there at his office. At the preliminary hearing, where Steins appeared in person, the prosecution played the video of Judge Mullins being fatally shot inside his own chambers. And in that short clip, a man who police identified as the former sheriff is seen firing multiple times at Judge Mullins, and as the judge attempted to hide behind the desk. Now, the preliminary hearing also introduced new information about the events leading up to the fatal shooting. Now, the Kentucky State Police Detective Clayton Stamper, the case's lead investigator, testified in court that the two men went to lunch earlier the day with multiple other people, where a witness allegedly heard Mullins ask Steins if they needed to meet privately. The context of that request is still unclear. But according to the police, video footage places Steins and Mullins inside the judge's chambers later that day. Now, in his testimony, the detective Stamper said that Steins subsequently made phone calls from his phone as well as Mullins. Those calls, the detective testified to, were to Steins' daughter. Now, the video shown at the October 1st preliminary hearing did not include audio, didn't show the calls being made by the sheriff. But after those calls were placed, police says that Steins then committed the shooting. Now, the detective also said that the phones had been sent to forensic labs for examination, and though Steins' daughter's phone had not been examined at the time, the detective said authorities have interviewed the daughter. Of course, they haven't told us what she said. Anyway, while the case has moved forward to the grand jury on the charge of murder, Steins' legal team is gearing up for a legal defense of manslaughter. Still going to prison, but he's saying, give me a chance to get out. In an interview last week, Steins' attorney, Mr. Bartley, said the shooting occurred in the heat of the passion, said he believes the highest level of culpability should be no greater than manslaughter based upon the defense of extreme emotional disturbance. Now we'll have to see what the grand jury returns. Remember, you can indict a ham sandwich, because the prosecutor says this is the evidence, here's the indictment, go ahead and sign right there, and we'll get you all out of here for the day. The grand jury really has no real authority in there. They could sure say, no, we're going to present a no bill, but, Steins' attorney is laying that groundwork, I guess. But the prosecutors get what they want in the grand jury. It's going to be interesting, and hopefully we'll get a little more information once the grand jury indictment is returned as to what was the nature of that conversation and why did the judge have the judge's daughter's phone number in his phone. Was it because the judge was helping out Steins' wife and daughter because the sheriff is a bad guy? Or was the judge engaging in something nefarious with Steins' wife and or daughter? We don't know. And so that's where the speculation comes in. The record needs to be cleared up, and when it does, we will bring it to you. Next, the Gilgo Beach case is going to come down to some new DNA technology. Interesting. That's right. The case of accused Long Island serial killer Rex Heuermann is headed for a showdown over novel DNA testing. The prosecutors say connects Heuermann to the murder of 6 women. And needless to say, Heuermann's defense team says that is magical conjecture. Now, Rex Heuermann appeared in a New York courtroom Wednesday to discuss the status of discovery and other evidentiary matters that needs to be resolved before this case can get headed down the trial road. Now, he appeared in a suit and had his handcuffs on, and the former architect stood silent during the 5-minute courtroom proceeding while the attorneys argued with the judge. Now, Heuermann's lawyer, Mr. Michael Brown, told the judge that he's waiting until he receives all evidence from the prosecutors before he can file any motions. And in particular, he's going to file a Fry motion. And that's to determine if the DNA scientific evidence that's being used is scientifically valid. Now, there used to be Fry hearings all the time on DNA 25 years ago. Now it's just been found to be reliable, and the evidence comes in if the proper foundation is laid. You don't have to have a hearing to see if it is some unique and novel DNA evidence. So we're going to have to wait and see what the attorneys are arguing about. Needless to say, the district attorney had a different spin on the situation, and they said that their office won't object to the hearing because they see this as an opportunity to prove the admissibility of the testing of the DNA, which the prosecutor says has not been used in New York criminal trial before this particular case. It's like everything. It's always getting just a little bit better. Before, you needed a lot of DNA, even though a lot was very minute amount, but now it's even less. It's amazing the small amount of DNA that they can do. Then they basically copy it to make it bigger and bigger so they can create the profile to see if it is in fact a defendant, or to exclude the defendant from that particular profile that's been made. Anyway, the judge told the prosecutors to complete discovery no later than December 17th. The judge also urged the parties to try and reach an agreement on what would be debated at this Fry hearing to avoid the need for motions and litigating on the particular issues. Judges are always wanting everybody to get along. The other parties are saying, hey, let's have a hearing. Anyway, prosecutors said in Wednesday's hearing that they have given the defense all the evidence related to the DNA testing in this case, including records from the Suffolk County Crime Lab and a private lab that provided the contested results, allegedly linking Heuermann to the victims. They have also said that they have handed over 99.9% of all raw data from every electronic piece of evidence collected from 400 devices. Now, after the hearing, both sides addressed the media, speaking for longer than the hearing took place inside. The prosecutor called the December discovery deadline ambitious, given the volume of evidence collected over the past 3 decades. And the prosecutor spoke at length about funding his office needed to comply with the discovery obligations, drawing attention to forfeiture funds that he said the federal government has frozen as part of a DOJ investigation. So in other words, the prosecutor doesn't have enough money to compile and get to the defense all of the relevant discovery in the case. Anyway, in addition to the hearing, Heuermann's lawyer said that he intends to pursue a venue change to sever charges relating to 2 victims who went missing back in the 90s. The attorneys accused the Suffolk County prosecutors of poisoning the jury pool with inflammatory comments about Heuermann's alleged guilt and demeanor. Heuermann's attorney spoke at length about the importance of the Fry hearing, describing that the contested DNA results as magical evidence that was generated by a for-profit lab on the West Coast after the Suffolk County Crime Lab was unable to link Heuermann to the victims using other forms of DNA testing. Otherwise, the attorneys for Mr. Heuermann told reporters that Heuermann was eager for his day in court. In the meantime, though, Mr. Heuermann remains in isolation at the Suffolk County Jail for his safety, even though Heuermann doesn't think he needs to be in solitary confinement. Next, Delphi. That's right. Opening statements are underway this morning in the long-awaited trial of the man accused of killing 2 teens in Delphi, Indiana, nearly 8 years ago. That's right, the trial of Richard Allen, accused of killing Liberty Libby German and Abigail Abby Williams in February of 2017 after allegedly luring them to their deaths while they were on a hike not far from their house. Now, their deaths has gone unsolved for more than 5 years when Allen, who was working as a pharmacy tech, was arrested in this case. Now, the trial of Allen, who is charged with the 4 counts of murder in connection with that killing, opening arguments were supposed to start this morning. Now, I don't have personal confirmation of that because, well, we can't watch it because the judge has denied us access to it because she thinks we're all stupid and we just can't handle seeing the facts. Anyway, with jury selection complete, the jurors selected in Allen County were then transported to Carroll County, and they will be sequestered for up to a month. Now, Judge Francis C. Gull, the special judge appointed to hear this case, heard from both the prosecution and the defense on some outstanding issues prior to the opening statements beginning. One motion from the defense sought to have the jurors taken to the crime scene so they can get a firsthand look at the layout of the Freedom Bridge, the Monon High Bridge, and the former building standing nearby. Anyway, the defense withdrew that request on Thursday, meaning that the judge didn't have to resolve that issue. In its original motion, the defense argued that such a trip would give a jury a greater understanding of the scene and how it related to evidence presented at the trial. The prosecution objected to the idea, writing in their response that the trip was just a waste of time and resources. The prosecutor was arguing that they're going to introduce all types of exhibits showing the layout, maps, drone footage, so there would be no issue that could not be resolved in a courtroom. Like I said, ultimately it was a moot issue because the defense withdrew their motion. Now, like I said, I've seen this a couple times now. I mean, 30 years of practice doing criminal defense, never done a site visit with a jury. We requested it once in a civil case years ago. It was an airplane accident case, and it was nearby the courthouse. And so we thought, hey, let's take him out there. The judge nixed that idea rather quickly, saying, we've got video, we've got photos, we've got measurements, we've got experts, we don't need to go. But it apparently is quite common, apparently more on the East Coast, as we saw in the Murdoch case. Anyway, not an issue. Anyway, the judge had another matter to consider, and that was a motion from the state to prohibit the pair of the composite sketches from the being used in trial. As you may recall, the Indiana State Police released sketches 2 years apart, with the first being revealed to the public back in July of 2017 and the second back in April of 2019, and both have become inextricably linked to this particular case. Now, these were based upon recollection of witnesses in the area, and for years, people attempted to find the various suspects based upon these sketches. Well, the first sketch featured a man in a hat and a hooded sweatshirt, while the second sketch showed a man who was quite young. Anyway, the prosecutors have filed motions seeking to have the sketches excluded from the trial, arguing that they were not used to identify Richard Allen and have no bearing on the case as it relates now. I think that the defense should be allowed to show what investigative work they did, and it should come in. Anyway, the judge is reserving ruling on that as of yet. Probably going to be a game time decision based upon how the potential sketches would be used by which party and what witness and what relevance it might be. But the judge also ruled that correctional officers and inmates are going to be allowed to testify about Richard Allen's behavior and comments that he made while he was in custody. And she took another motion under advisement regarding the expert defense witness planned to call to discredit ballistic analysis central to the state's case. That's expert testimony. It should come in. I'm not sure why the issue is on that, why the judge would even consider not allowing that witness to testify. Like I said, the opening statements should be ongoing as I'm filming this video. If only we had video, Judge Gall, we could see if both sides were getting a fair trial. Maybe next time.